Your Honor, before we go live.
Oh, I get it.
Yeah.
So.
The live stream is starting on this matter. Let me just go ahead and call the case CR 22-21-16-23 State versus Chad Guy Daybell. Mr. Daybell's here present, represented by his attorney, John Pryor. The state's here represented, Mr. Wood, Ms. Smith, Ms. Blake, Ms. Rawlings. I'd also note Mr. Archibald, who is a co-defendant's counsel, is present as well for the hearing. We're conducting this by Zoom. We are recording this on the court's FTR system and the Zoom software. We're also live streaming this on the YouTube channel of the Idaho Supreme Court for this court in order to allow public access for this hearing. We've got two matters on the docket today. One is a scheduling conference. The other is a motion hearing on Mr. Daybell's case. Counsel, before we get started with the scheduling conference, are there any initial matters we need to bring up?
Your Honor, the state had intended to ask essentially to speak in chambers or approach. Of course, that's a little bit different on the Zoom hearings, but there are a few issues that we believe need to be discussed off the record prior to moving forward with the motion.
Okay, why don't we bring that up at such time as we are ready to start the motion, then we take a break and have a breakout room set up. Are we able to proceed at this time with the scheduling conference?
I think we are, Your Honor. I would also indicate, it's my understanding co-counsel Mr. Means is also present. I believe with the scheduling conference, the court's indication has been this is one trial, but I think the state is ready to proceed with the scheduling conference.
Okay, thanks, Ms. Blake. And I'll also note, I do see it looks like Mr. Means is appearing telephonically. And with the case currently scheduled for joint trials between the two defendants, I think it is appropriate if counsel for the co-defendant, Ms. Vallow Daybell, are present, although the court would note that case continues to be stayed pursuant to Idaho Code 18212, pending restoration of competency of that defendant. So with that in mind, I would like to start off with our scheduling conference. Counsel, I'll start off with the state with proposals on when we can get this case on the trial calendar. Then I'll ask the defense. We've had some discussion about this prior to today. I understand the request, as I learned from previously, was for approximately 8 weeks to be scheduled for the trial. So I'd like to first confirm if that's the proposal on the amount of time being requested, and then let's look at dates when we can get this matter set. So Mr. Wood, why don't I start with you? Is the 8-week time frame still what the state would be requesting to try this matter?
I think that's appropriate, Your Honor.
Okay.
If any of my co-counsel disagrees, that's fine. I think 8 weeks for at least the trial. I don't know if that includes jury, picking a jury or not.
Your Honor, can we stop for just a second? For some reason, I'm getting a lot of feedback and I can't mute my YouTube. There we go. We're good.
Okay, thanks. If you run into that issue again, just let me know. In terms of setting, I would like it to include, of course, jury selection.
I think to be safe, then, Your Honor, we would say 10 weeks.
Okay. Mr. Pryor, before we set dates, then what are your thoughts on a 10-week trial setting? Do you think that's too much, not enough, or just right?
Judge, I took the liberty of examining what Mr. Wood and Ms. Blake and Ms. Smith have disclosed to me in terms of their witnesses at this point. And I did some planning, and then I coordinated that with the witnesses that I anticipate calling. And there is obviously some significant overlap with those witnesses. I anticipate about a 1 week to pick a jury, and I expect about 7 weeks in terms of testimony to the conclusion of the trial. So I would politely disagree with Mr. Wood, and I think that, quite frankly, a 6-week time frame should be appropriate.
All right, I may have missed the math there, Mr. Pryor. I thought you said 1 week for a jury and 7 weeks for
6 weeks, Judge, total.
6
I'm
weeks
sorry.
total?
If I said 7, then I misspoke, and I apologize for that. I think a total of 6 weeks would be sufficient, Judge, total, including selection of jury.
Okay. Well, my thought is schedule it out as long as we need, and we can always conclude the trial early and then fill our calendars in as we see that happening. But I'd rather not run out of time and have other settings. As everyone is aware, you all have other caseloads, as the court has another full docket of cases in the 3 counties I cover as well. So my thought is to err on the side of caution. And let me just go back to you, Mr. Wood, after hearing that. Are you still thinking 10 weeks would be a necessary time frame in order to get this tried?
Yes, Your Honor. And from the state's perspective, that's built in with caution. Hopefully it doesn't go that long, but just to be safe so that we don't run into other scheduling issues.
Okay. Well, based on that, I will set it for 10 weeks. We'll of course do our best to move the trial along and as efficiently as possible and use the time we have. Hopefully it wouldn't take that long, but if it does, again, I'd rather have that schedule set out in advance than run into having to emergency move other hearings because we went over. So with that in mind then, Mr. Wood, what is the state thinking in terms of when you'd be able to be prepared to put your case on and start the trial?
Your Honor, the state again is going to take an abundance of precaution approach. What we don't want to do is schedule a trial and then have parties moving to continue it. We'd ask that the trial be set in September of 2023.
September of 2023. So a year and 10 months.
Yes.
Mr. Pryor, what are the thoughts on behalf of your client for starting the trial?
Well, Judge, I guess what I'm doing is I'm presuming that since Mr. Daybell's been in jail for about a year and a half, Mr. Wood has probably provided me all of the discovery. At least I would hope he has by this time. I know I just got a recent batch again, a 3rd supplemental last week, but I would think after all of this time before charging Mr. Daybell, he would have had all of the discovery gathered and he would have provided it to me by now. So taking that into consideration and assuming that they're not going to drop any more surprises on me, I have my expert witnesses lined up. I have what I need to do. I will be disclosing all of my witnesses to Mr. Wood shortly. And my preference is to start the trial in October of 22.
All right. Well, obviously there's a big difference here. The court also has some duty here to administrate my caseload and manage it in consideration of all parties here in the nature of this case. I did look at a lot of different factors, including the in custody status of the defendant in this case. I understand there was a waiver of speedy trial. However, there is still an obligation of this court to provide a trial as soon as possible, especially and in particular where defendants remain in custody. September 2023, quite frankly, seems really distant for me. And I guess, Mr. Wood, I would like some additional information about why the state believes an almost 2-year delay from now until the time of trial would be necessary. Can you give me some explanation as to why we would need to wait that long?
Partly, one, Your Honor, is an abundance of caution. 2, as we've looked at other similar cases, very high-profile, complicated cases, these trials usually take 2 to 3 years to get. These cases usually take 2 to 3 years to get to trial. We have a lot of issues with taking care of if we are going to over to Ada County. That is an extremely tedious thing for the state to have to do. That's not something that can happen overnight. So there's a lot of factors, Your Honor. It's going to take a lot of time for the state to coordinate that. That's why we're asking for that time. And again, we think with that date, it's not going to get continued. It goes. Everyone's ready to go. I would quickly note, Your Honor, where it is still a joint trial, like the state thinks it would be appropriate to ask Mrs. Daybell's counsel when they think trial would be appropriate.
Okay, and I guess I will inquire. However, obviously that's very speculative because no
Sure.
one knows when competency may be established. But Mr. Archibald, do you have any thoughts on when you may be prepared for trial, or other than speculation as to when you may have a competent client?
No timeline as to when she may be restored to competency. Those are issues that we can talk about privately. And as far as the trial being set either a year or 2 years from now, it does take some time for mitigation. The process with mitigation specialists and investigators, that process has not started yet because of her incompetency, and whether or not she'll waive her right to speedy trial is still an issue that she cannot decide at this point. And so I think the general timelines, yeah, it does take 2 to 3 years to get a death penalty case to trial, if that's what the state is seeking. And they are complicated cases. And so thinking logistically, Fremont County typically has harsh winters. So I would just not want it set in November, December, January, February, March. Those are typically difficult seasons for a lot of traveling if there's witnesses coming back and forth.
Judge, I'd like to respond if I may.
Go ahead.
Judge, I noted that Mr. Daybell's been locked up for a year and a half. Ms. Vallow's been locked up for a couple of years. And with all respect to Mr. Archibald, it's not Mr. Daybell's fault that Mr. Archibald has not started any mitigation process. It's not Mr. Daybell's fault that they may not be able to get their expert witnesses lined up. I would assume for the last several months, that's what they've been doing because they haven't had to file anything else. So they've got 10 months from now to have a trial. And I think that that's more than sufficient time, given the fact that for a year and a half, there's been at least from my perspective, a battle to try to get all of the discovery. Now, if Mr. Wood decides and Ms. Smith and Ms. Blake decide to dump some more discovery, then that'll be an issue that I'll address with the court. But I'm assuming now that after all of this time, that I have all the information that they intend to use in this case. And given that, I can't fathom how Mr. Daybell should be kept in jail for another 2 years, awaiting his opportunity to offer his explanation of this case. And because Mr. Wood doesn't think that he can get ready in that much time. And frankly, he made a representation when I asked for a continuance and waived speedy trial that he was ready for trial. And he's made that representation to this court. Now, if that was an inaccurate statement that Mr. Wood made, that's fine. But he did make that representation in open court, that he was ready for trial. So now if he's saying 2 years later now, because Ms. Vallow's locked up, and he doesn't know what's going to happen with her. And I suspect that's what the reason is. And that's not a legitimate reason to delay it for Mr. Daybell. He wants his trial and he wants his opportunity to present his case.
All right, thanks, Mr. Pryor. The scheduling of the case is, of course, a matter of discretion for the court. And I've considered the positions laid out here by all sides. Quite honestly, my hope was to have this case tried in 2022. I'd note that while the case at bar here was started in May of this year, it was initially Mr. Daybell was taken into custody and arrested in related case that stemmed first and went into this case. And that occurred back in June of 2020. So that was almost 18 months ago. So even if we looked at a 3-year setting from when he was initially charged, we still wouldn't be to the fall of 2023. And I understand the burden. Well, I won't say I understand it. I've been a prosecutor before, not on a case like this, but I understand it's a huge undertaking, would require a lot of time and preparation, and I want to afford the state that opportunity. But I also have to weigh that against the interests of a defendant to have a timely trial, waiver of speedy time or not. And so in consideration of all of that, I've also done some checking of my own with calendars, coordinating things with Ada County where this trial is scheduled to occur. And I've determined then that an appropriate time to be looking for trial will be in January of 2023. So that will still provide 14 months of preparation time from now going forward. There's other motions I understand still need to be litigated that could impact things and need to be scheduled as well, in particular the motion to sever. But in terms of setting trial, I do want to get it on the docket. There's a lot of planning that goes involved, a lot of scheduling issues, and I don't want to be looking at the prospect of having to move the trial once it's set. So upon all those considerations, then, counsel, I'd ask that you start looking at your calendars right now and let's see what would be available in terms of a commencement date in the month of January 2023.
And Judge, without permission to speak up, I will make a representation to the court that whenever the court decides to set it in January, February, or March of 23, I will be available for whatever the dates the court decides.
All right. I would propose a starting date of January 9th. So if we started January 9th,
Your Honor, the state's one concern with January is travel back and forth. Mr. Pryor himself has said that our officers can travel back and forth, so that's the position he's taken. That puts us that could very easily put us in a bind. I think even moving it to late February would be a lot more appropriate.
Judge, I think January is going to be fine. We're basically dealing with highway traffic. And having been dealing with this for the last 18 months, traveling between, and quite frankly, really visiting with Mr. Daybell quite frequently in the last 18 months, it's not as difficult of an accommodation as it seems to be suggested.
Well, I highly disagree with that.
Okay, that's fine.
again, it's a speculative issue. Some winters, the interstates are clear all through January. Sometimes it's a nightmare getting from here to Boise. We don't know and can't predict that. It's one factor to consider, but the court would consider that where the trial would be occurring in Ada County, the climate there is much more mild than it is in Fremont County. That alleviates some of that concern. I still would like to consider that start date of January 9th, because then that's going to put us out to, I think it's March. If we wanted 10 weeks, then that would be March 17th or March 24th for an end date. I believe that had put it through March 17th, if I'm counting up all the weeks correctly. Is there any specific objection besides what's been noted in terms of weather or convenience from that setting March 17th as an end date, January 9th to begin?
It's acceptable to the defense of Mr. Daybell, Judge.
We will be ready, Your Honor.
Okay. Well, I appreciate your input on that, counsel. We'll get a scheduling order to that effect. That scheduling order will contain some deadlines for counsel to pay attention to in terms of discovery cutoff, expert witness disclosures, and other matters that are set in accordance with the Idaho criminal rules. So we'll send out a scheduling order on those dates. And while we're talking about scheduling, I mentioned it a little bit previously, but what potentially has some real impact here is the filed but not yet heard motion to sever. And Mr. Pryor, is there any reason why we can't get that on the calendar as well?
We can, Judge, but before we do that, in fact, my preliminary motions as they affect the motion for sever have already been drafted. I had anticipated filing them, but they were going to be filed before this hearing, so the court knew where we were. But I received a response to my motion that's coming up from Mr. Wood's office the other day, just yesterday, Tuesday. And I had to take an opportunity to review that and do the research on his last minute response to my motion. So as far as the motion to sever, Judge, and I'm not submitting argument counsel, any of the counsel, but under Rule 14, before the motion to sever is heard, there is a requirement that the court can impose on the state to provide me statements that they intend to use in regards to Ms. Vallow and Mr. Daybell, and to give me those statements. And it's addressed on the latter part of Rule 14. I was going to file a motion asking the court as to whether or not you're going to require the state to turn that information over to me prior to hearing the motion to sever. And if the court wants a formal hearing on that, we'd have to set that first and then the motion to sever. And then, Judge, that's the way I'm reading the rule. But I would expect the motion to sever can be heard probably within 30 to 45 days, if that's acceptable to the court.
All right. In lieu of setting the hearing on that today, counsel, just be aware that I do want to get that on the calendar under Rule 14. If you think a preliminary motion is required, Mr. Pryor, file that motion.
I will do that.
We get that heard on a shorter time frame, and then we can look at getting the actual motion to sever calendared, and I'll bring that up with counsel at a later date. I would like to hear that sooner than later, as again, that's going to impact potentially the trial in this case. So,
Judge, if the court wants to set a time for my preliminary motion on the severance per Rule 14 that talks about the statements that both co-defendants would be used by the state against each of them, and the requirement, and it's not, and excuse me, Judge, it's up to the court to decide whether they're going to require the state to provide me those. That's what my preliminary motion would be, and I can have that ready at any time if it's a concern that we need to get the severance issue heard. So if the court wants to set that motion today, I would gladly entertain that and make sure that by either day's end or by tomorrow, I have my request for that information done promptly to this court. So I'll entertain if the court wants to set a hearing on that right now.
all right. At this point, I'm going to interject for a moment. I think we're getting some feedback. I think it's probably coming from Mr. Means, who's not on mute. Mr. Means, thank you. Counsel, in terms of a potential hearing date coming up on a motion, we could have either December 22nd or 29th available.
Your Honor, we'd like to see that motion before we agree to a time that we
Okay.
if we need to respond to it.
Well, they are going to see it, Judge. Today's the 3rd, or excuse me, today's.
Well, I don't have it yet, Mr. Pryor.
You're
Yeah,
right.
Mr.
You'll
Pryor,
get it.
if it hasn't been filed yet, I'm not going to set it for hearing.
Right.
Just pencil on, if you want to get a hearing set, I've got the 22nd and 29th. Get the motion filed, and then we'll look at an appropriate time for a setting once it's been
Okay.
filed. But I agree with the state. If it hasn't been filed yet, we don't need to set it for hearing.
Okay.
All right. I think that will conclude then the issues relating to the scheduling of the trial in this case. We've next got a motion, and I understand council would like a sidebar with the court, which will be conducted in the form of what's called a breakout room, where we'll be off, well, we won't be off the record because I'll have the court reporter record what is stated in the breakout room, but we will not be broadcasting that to the public on the YouTube stream. So, Madam Clerk, if you could please set up a breakout room for all council. Then once you see that invite, we'll do that, confirm that it's not being live streamed, and then we will discuss the preliminary issues to that.
Apparently I got sent to my own breakout room. I don't know what happened.
I don't either because it just started putting people in rooms. So I'll move you in there.
Okay.
And I'm just staying out since I'm screen sharing.
All right, Madam Clerk, are you ready?
Sorry, I was muted. Yes, we are ready.
Okay, thank you. Is the court reporter ready?
Yes, Your Honor.
Okay, thank you. We're back on the record on this case, State versus Daybell. We had a discussion with the court reporter, but not live streamed. Based on the content of a lot of that discussion, the court does find grounds for closing and sealing that portion of the proceedings based on the fact that the discussion in large part entailed issues related to the competency and treatment of the co-defendant, Ms. Daybell, in case CR 2221-1623. I would note that all counsel were present for that hearing, section of the hearing, including her counsel, Mr. Archibald and Mr. Means. So the court does order the sealing of that part of the record of these proceedings. What we got to were the issues raised in these motions that were filed. In the companion case that I just mentioned, 1623, Mr. Means filed a motion on October 27th. And then as a response partially to that motion, the defendant here today, Mr. Daybell, and his counsel filed their motion on November 5th, titled "The Motion for Discovery Concerning Events That Were Revealed in Lori Vallow's Motion," dated October 27th, 2021. There was a hearing scheduled on the matter today. After discussion with counsel, the courts determined that it's not yet a ripe issue to bring before the court for several reasons. One, and chief among them, is the fact that additional facts were submitted in the form of an affidavit in the 1623 case, to which Mr. Pryor has not been made privy because that was a sealed affidavit that was filed at the request of the Department of Health and Welfare through counsel. The court would note that that counsel is not here and available for the hearing today, and there's a few questions that need to be determined. Number one, the question of whether or not the stay in effect in the 1623 case pursuant to Idaho Code 18211 and 18212 would prohibit a hearing on the issue. And I have to do some research and determine whether or not it's appropriate to have a hearing in that case based on the stay being in effect. The second issue then would be whether or not the information disclosed through that affidavit should be revealed on a limited basis to Mr. Pryor and his client as it relates directly to their motion. And I'm not going to make that determination until I've had an opportunity to receive the Department of Health and Welfare's thoughts on that through their counsel that filed the pleadings. So we're going to need to continue this hearing to sort through those issues and allow additional counsel from the Department of Health and Welfare to be involved. The court will consider the matter under advisement, understanding the objections that have been raised by both defendants, and go through the issues of both the stay and the involvement of the Department of Health and Welfare. At such point, we would likely have another hearing scheduled that would join the two motions to a single hearing for efficiency purposes. We don't have the capability currently of setting that hearing for today until I get through the other issues about the stay. So with that in mind, then the court is going to vacate today's hearing on that motion. It'll be continued to a later date to be determined by the court with assistance of counsel and looking at their calendars. So I believe that's where we're left for the day. Mr. Pryor, it was your motion I was just discussing. Do you have any questions or anything else you need to raise before we conclude this afternoon?
Nothing further, Your Honor. Thank you for the explanation.
All right, thank you, Mr. Pryor. Mr. Wood and Ms. Blake, do you have anything?
Nothing further on this today, Your Honor. Thank you.
Thank you. Okay, I think that will conclude the matters that were scheduled for today's hearing. Then we'll get together with counsel to determine a future date for the next hearing. And again, we'll set forth the scheduling order will be filed in the case as well. So I appreciate everyone's attendance today. That will conclude the hearing and we'll be in recess.
Thank you, Judge.
Thank you, Judge.
You're welcome.